live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to this special episode of Surviving the Survivor live coverage. Best trials. Here we go. Shanna Gardner, who is accused in a case very similar to the Dan Markel, Charlie Adelson, Donna Adelson, all things Adelson case, is due back in court this morning at 9 a.m. And yours truly actually completely had this off his calendar, but that's why I have Tim and Space Coast here to remind me. And the pool camera here is supposed to be First Coast News out of Jacksonville. And I already see True Lifestyles has been following this case for us. By the way, today, and True Lifestyles reminded me of this, is the 2-year anniversary of this horrific murder. So Tim Jansen, particularly poignant, 2 years to the day. Valentine's Day, which was 2 days ago, was their last holiday together. Kind of a sad date here, and ironic that the defendant will be in court for this, isn't it?
Yeah, it's horrible. It's horrible for the family. And justice, usually takes a long time in murder cases. It can take years. During the COVID, it really set back trials, serious cases, probably 2 years. Big murder cases. Courtrooms were closed. Inability to take depositions, experts, people to travel. It really was, and I don't think a lot of people realize the shutdowns really affected the judicial process and the legal court system a lot. It really did. And it backlogged a lot of the trials so that when they did open up, they had to get the trials that were backlogged. So I don't think the system is actually caught up yet. Maybe another year or two.
Wow, it's backlogged that much. That's kind of nuts. Space Coast on the West Coast, who's, obviously very early there. I just sent you, there's also a GoFundMe page. The Bridigans need help. And if Space Coast can share that, I just sent it to you, Space Coast. But again, it is the 2-year anniversary of Jared Bridegan's murder. So let's keep him on our, top of mind today as we go through this. One of the things that we talked about, we had an excellent panel on this. And by the way, we're going to be diving deep back into it on Monday again and retracing everything that happens in the hearing today, was the fact that the Bridegan family has filed suit here, a civil suit, or I guess it's more of a custody type battle for visitation rights for the 11-year-old Gardner twins that that Jared shares obviously with Shanna. Tim, in that kind of a suit, are they just simply looking for visitation rights? Is it just like a family court type deal, or are they looking for damages as well?
If it's in the family law court, they'd be looking for visitation. If they was filing a wrongful death suit, that would be for money against the family. Or against Shanna. I don't think her new husband has any money. I certainly don't think the man that shot him has any money. So it'd be a wrongful death against Shanna. I don't know what money she has. If she has money, if it's in trust. If she has money in trust, it'd be hard to get to. Remember, like OJ, he had a pension. Remember, he got a judgment against him, but he had that NFL pension of like $10,000 a month that they couldn't get through it. So he was still getting $10,000 a month from the NFL.
Yeah, he's still getting paid. I think it was more than that, but he was getting paid. Yeah, big money. So just to go back over the charges here, of course, it is both Shanna Gardner and her now estranged second husband, this guy Mario Fernandez Saldana, each charged with first-degree murder, conspiracy to commit first-degree murder, and child endangerment counts in connection with Jared Bridegan's death. Obviously, the most serious of these is first-degree murder and then the conspiracy charge. Tim, what's really the difference here between first-degree murder and conspiracy? they're both attempts to commit murder. What is the difference? And by the way, here is the Bridegan GoFundMe link. So you could probably just find it if you go to GoFundMe and put in either Justice for Jared Bridegan or Jared Bridegan, and True Lifestyles here filling us in a little more. It's a custody lawsuit filed by the Bridigans for visitation. But what is the difference between first-degree murder and the conspiracy charge?
Well, just remember, conspiracy, all you have to do to prove a conspiracy is that two people agreed to commit a crime. The conspiracy is really the agreement. First-degree murder would be actually committing the offense, and the penalties can be the same. So one is just the agreement. They do a lot in federal court, conspiracy to distribute drugs, and you'll have defendants say, hey, don't have any drugs in my hand. They can't convict me. There are many people in prison for conspiracy. And what conspiracy also does, it opens up a lot of evidentiary issues. Statements that would not otherwise be admissible are introduced as co-conspirator statements, so they're not hearsay. So as long as it's in furtherance of the conspiracy. So federal courts, it's a powerful weapon to use conspiracy because all you have to prove is an agreement. And that's what they do in federal court every day. It's a very powerful tool.
Look at this, Mandy May in Finland, and look, we're already getting a shot of the courtroom here. It is about 8:56. This is the pool camera. This is usually what they do.
I think he went out last night.
Yeah. This is First Coast News out of Jacksonville, so courtesy to them for being the pool camera. But this is, Tim, we keep hearing about these courtrooms. It's like a show courtroom with a double jury box. It's a really beautiful courthouse. Almost looks like your office a little bit, Tim.
A little
Jansen.
bit.
Yeah.
Well, I don't have room for two jurors, but I can tell you the Duval County Jail is horrible. One of the worst jails I've ever been to. Downtown Jacksonville. It's like a 8-story right on the water. It's just awful conditions. Really?
I'm glad I'm not there. Look at this, Mandy May in Finland. Love this timing. Able to catch a live. I watch every single episode, usually in replay crew. Welcome from Finland, Mandy May. I don't know if I've seen your name before, but good to have you here. Tim, people are asking, what is this hearing about? And the truth is, we're not 100% sure, but we think it could be an evidentiary hearing as opposed to a case management hearing. What would be the difference there?
Well, an evidentiary hearing, like I explained yesterday, whether a court is going to take evidence. If you saw yesterday, you heard what was going on in Atlanta. They had an evidentiary hearing on whether to kick off Fannie Willis on the trial. So they called witnesses, and the judge took testimony. It was cross-examination. If they have a hearing this morning, they will call witnesses. They'll have cross-examination. They usually schedule that on a Friday when they have more time. So it could be an evidentiary hearing is why they moved it to Friday, or because of the judge's calendar. If it's going to take more than an hour or two, they may have moved it to take evidence. And those ceilings, you don't see that in a state courthouse. Sometimes you see it in a federal courthouse because the feds can spend money crazy, GSA. But that is not a typical state courthouse at all.
Yeah, there was talk that it was once a federal courthouse that switched over, but I don't think it is. And but it is, no matter which way you slice it, it's a beautiful looking courthouse. It literally looks like something you'd see out of a movie. And like Tim said, there are 2 separate jury boxes.
Wow.
So that's one of the other questions here, Tim. Like, does this case get severed? Because right now we've seen Shanna Gardner and her estranged husband, Mario Fernandez Saldana, appearing together. Any guesses today if we see both of them come out today again together?
You know, it'd be interesting. I wish I knew what the motions were, what the hearings are. A lot of times these hearings affect both defendants. So it could be a joint hearing or it could be a single hearing. Having the trial together with separate juries is much more convenient for the court and the system. It's problematic for the clerks of the court and the jurors and the deputies who have to move in and out these jurors. But remember the last trial we had with the crazy lady and they severed it because of Bruton issues, and she was convicted and the husband's still setting to go. They wouldn't have had that problem if they had this courthouse.
Mm.
That's a
Melbourne,
nice. That looks like a former federal courthouse. That
yeah,
is what a federal courthouse looks like, Joel.
it looks like they're shooting a movie there is what it looks like. One of the things here, Tim, that came up, and I'm glad Jamie Justice brought it up here. There was a motion for bond for Shanna Gardner. It's not going to happen, right?
No,
As
she's
much
not
magic.
getting bond.
Yeah, I mean, as much magic as Jose Baez can create, that's not going to happen. The other thing, obviously, that everyone's been talking about is you see, I'm looking at another. If I can get to it here, someone's giving us a little history lesson on the courtroom.
Oh, they are.
Well, they said the state attorney's office is in the old federal courthouse next door. So there you go.
Okay.
So, what was I just saying? One of the other issues, obviously, is severing the cases. The other one is we've seen in the past Shanna in street clothes looking demure, but you see Mario Fernandez Saldana in a jumpsuit. Do you think today we see Shanna in a jumpsuit or in these regular street clothes that we've been seeing her in?
I think she should be in a regular jail outfit. I don't, that's really unusual to have them in street clothes just for a hearing. Now, it's a public trial. It's going to be aired. So maybe they've convinced the judge in chambers or they filed motions under seal that it's prejudicial to my client. Potential jurors could see this and know she's in custody. They really don't want the jurors to know the person's in custody. And they take great efforts because they figure if you're in custody, you're a really bad person. They don't want that inference. And most courts try to do that to protect them from knowing. And they also try to protect jurors from knowing if the person has a public defender. They will never say that because they don't want you to think they're poor and spending taxpayers' money. So that courts really do try to give the indigent and the poor a fair trial and make it look like it's a fair trial that everyone else gets. And that's what the process should be.
By the way, we're about to watch live coverage of another court hearing involving Shanna Gardner, who's accused of murdering her ex-husband over custody issues. His name was Jared Bridegan. People are telling me that Kirsten Bridegan, who is his widow, is in the courtroom. I didn't see her yet, but they have been coming. Her and her sister have been coming.
It might be like 9:15.
And you hear them talking in the gallery. Someone just said it was supposed to be 9 in the gallery. It might be 9:15. But either way, they're
here
getting
comes
ready
the
for this trial.
defendant, Saldano.
Okay. Let's see.
He's coming in.
So they are going to be here together today. Oh,
well, they're going in to see him. So what they normally do is they let you go in a room privately and talk to your client. Oh, he's sitting over there. Okay, so he's sitting with his client, his lawyers, and they're discussing things. He's in a jumpsuit, and it's curious to see if they bring the woman in the other way, or if there's another way. Normally, courtrooms have one entrance for inmates, so they may have separated him and bring him in first, and then bring her in later.
Look at this, Arizona Amy. These courthouses are updated because they know STS is 100,000 strong, and they will be shown. Followed by Joel in the COE and Tim Jansen. Come on up to Jacksonville. Tim's almost there, and I'll give you a tour of the courthouse and the secure areas. I would love to do that. T60, if you work in the courthouse, hit me up, survivingthesurvivor@gmail.com. We'll be up there for a book. Tim, I'm setting up a book tour as we speak in Tallahassee.
Yes.
I'm excited. It looks like it's going to definitely happen.
You're going to do it at Heart and Soul?
I believe so.
That's a great location. I should have thought about it. That's a great location.
Yeah, and thanks to Carrie Zimmerman, who I met during the Charlie Adelson trial, we are going to be heading there, and hopefully we'll get a big turnout from Tallahassee and Jacksonville. It'll be great to see everyone up there. But yeah, there's Mario Fernandez Saldana. It is an odd couple. He's a short little guy.
Yeah, he's not liking what he's hearing. Didn't look like he liked what he heard.
He's much different looking physically, let's put it this way, than Jared Bridegan, and he doesn't seem to match Shanna Gardner. And some people are saying, it is a an odd couple, and maybe he was brought into this relationship to do untoward things, like maybe put a hit out possibly on her ex-husband. Perth, Australia is in the house here. The other thing, Tim, that happened recently with this case, and we talked about this pretty much in detail, is this document dump. Literally hundreds of pages of documents that were dumped. And so Carrie Zimmerman is in Tallahassee. She's well known. She has a PR firm, and she actually
Miranda's really smart. Joel, looking at the comments, Heart and Soul used to be Mosaic, where Wendy got picked up by the police the day of the murder. That is true. That used to be Mosaic, a restaurant.
Wow.
Where Wendy was picked up the day of the murder.
That's wild. I don't even see.
I didn't mean to interrupt you, but
no. I didn't even see the comment, but that's kind of crazy. The irony and how small it is, and the fact that we're going to be there for a book signing. So that is kind of crazy. The COE has appeared. She was doing school duties this morning, and it's been utter chaos. Will Shanna's parents, Tim, have any repercussions for lying on forms about where the twins have lived and who should have access to them? They have custody. They've not been very forthcoming. Can they pressure these very wealthy parents in any way?
Well, I don't know what forms they filed. If they filed them with the court, they could be held in contempt if they filed them with the court. They're going to have a lot of money, so they'll be able to hire a very high-priced, experienced lawyer to fight that. A lot of times the court won't hold them contempt. They'll do their administrative policy to try to fix that and give visitation. Remember, family law courts try to be a court of equity and do what's best for the children, but the parents don't always do what's best for the children. Family law is a very difficult practice. It really is.
This is a comment, by the way. This is kind of eerie. Heart and Soul. This is where I'm going to have my book signing for Surviving the Survivor, which is available on Amazon. Used to be Mosaic, where Wendy got picked up by police the day of the murder. By the way, I just got the hardcover design, and I put it out on Twitter at Podcast STS and Instagram at Surviving the Survivor. So if you want to check out what the book cover with Carm and I look like, here we go.
We don't see any of Baez or that defense team, do we?
Nothing yet. Judge London Kite presiding, although I don't know if that looks like her. We're about to find out. Yeah, that is her, I believe. Judge London Kite. She's great. So it looks like Fernandez Saldana is going to be the first one up. By the way, you're not going to find this anywhere else. You might be watching Court TV, you might be watching Long Crime, but you're not going to have Tim Jansen telling you what's going on as it happens.
So Mosaic and Heart and Soul is about 200 yards from the gym, Premier Gym, where they followed him to execute him. Wow. Here comes Shanna.
There she is.
What does she got? I can't tell. Too much security. I can't tell what she's wearing.
Good morning. I'm Ashbury for Ms. Gardner, who's present, and Mr. Baez and Mr. Sullivan are on Zoom.
Mr. Baez on the phone.
Good morning.
Okay, let's listen in now. They don't even look at each other, these two, but let's listen in here.
All right. Austin. Sir, turn your camera off, please. Officer.
I got it.
All right. Okay. Where's Mr. Baez?
Mr. Baez is in a place where he's not able to. He's listening, Your Honor.
Oh, okay.
Yes, sorry about that, Judge.
Okay.
I will be speaking the least today, so.
Right. There is a gentleman from Fields Automotive, and that didn't look like you. Okay.
No, it's not me.
Okay.
It looks like she's in street clothes with a sweater.
On my desk, there's a defendant's motion is scheduled.
Jose Baez just said, I'll be speaking the least, but he'll be getting paid the most. He didn't say that. He didn't say the second half of that, but I did.
You want to give me just a moment?
Yes, Judge, that's fine.
Okay.
Thank you, True Lifestyles.
She does have curly hair. I wonder how she's getting her hair done in Duval County.
Mm.
His hair is almost as long as hers.
Yeah, unless it's natural. True Lifestyles, I don't know if you know this, but we've seen Bridegan family. I don't know that we've seen Shanna's family in court, but have we seen Mario's family? Let us know in the comments.
Lori Vallow.
Quick shout out. Ooh. Just lost my. Oh. Thought I lost my microphone. Quick shout out to Julie Frew in the UK. Shout out to England. Shout out to Mish Cavernos coming to us from Cape Town, South Africa.
Did someone say that Baez is teaching at Harvard Law School?
I thought I heard that last time. Is that actually true?
Can that be real? Can that be real? Jose Baez teaching at Harvard Law?
We'll have to look that up. If anyone knows, let us know. STS Nation always knows before we do. D Mars giving us a little hair tutorial. They braid their wet hair to give it curls. And look at this. Emily says, yes, he's teaching trial advocacy at Harvard Law.
God. You know, the Ivy League schools have taken a big hit recently in some of their decision making.
I don't know if you guys have this, but up in New Jersey, we have like the Rye Technical Institute where they teach you to be like a car mechanic. That's where I'm going to send my kid, where you actually learn something real. Screw Harvard. My kid's not going to Harvard. Yeah, look at this. Harvard has gone downhill.
I've got to say they've lost their esteem in the public's eye, I believe.
I do too. Kenneth White, unfortunately, we cannot control any of this coming from the courtroom. This is actually First Coast News out of Jacksonville. They are the pool camera. And let's listen in here. This is the state talking right now. Space Coast, unless you can crank it on your end, I don't know, but
trial dates.
The motions filed by defense regarding the disqualification the week of March 11th and Ms. Arthur's hearing the week of March 25th. And I think that's
Arthur hearing's a bond hearing.
That's March 25th.
File our written response to their bond motion and handle this other matter.
All right, let me first hear from you, Mr. Carter. What's your position?
Judge, I'm
Those dates, on those dates.
Judge, I would need to speak to the other counsel involved in the case before I was able to confirm with the court.
Okay.
We've asked.
I mean, as far as the way that I'm reading your motion to schedule an evidentiary hearing and memorandum of law is that you believe that the state of Florida has had sufficient time. You wish to push forward regardless of the court's ruling on a disqualification. Am I reading that incorrectly, or?
No, that's our position. And one of our major concerns is if we are successful on disqualification, we'd be back before the court with the new state attorney's office, and they'd be begging the court for more time to get up to speed on the case before they could have the evidentiary hearing. So it's our position, and our first available date is March 5th, and we'd ask for March 5th, Judge.
So it sounds like they want to do the disqualification hearing first before they do anything else. Because as you said, if they get disqualified, that new state attorney will have to come in and delay the trial.
The things you learn, Judge London Kite has a sister named China London, or China Kite.
It says, while the law is clear that a trial judge, upon a motion to disqualify him or her, which that's not necessarily the case, you're asking to disqualify the state, must first rule on the motion for disqualification.
So, Judge, that was referencing a motion to disqualify the trial judge, where it's an all stop and the judge can't rule on any other motions. there is no case law similar for a motion to disqualify the state attorney.
So it's your position that it is not an all stop.
That is our position, Judge.
With, are you taking into consideration what has been alleged against the state? And to me, it's a little bit different. So let's say it's the evidence that they potentially would produce to the court, which is one of my concerns about hearing any motion. If there's contested evidence, right? And then that would be presented in front of the court. That's what I don't know. Obviously I haven't seen it. I don't know. Do you have any of those concerns if we went forward with the bond hearing?
Judge, I have some concerns.
Based on your review?
But based on my review, I don't know any other way, Judge, because my client's been sitting in custody for a long time now. The state has had an awful long time to prepare for any evidentiary hearing on a bond. I mean, I think it's disingenuous for the state to say they need more time to prepare when they've already presented this case to a grand jury, and they're well aware of all the evidence out there. To our knowledge, they've completed all testing. So I wouldn't understand how they would need more time to prepare. But with regard to the state's, the court's position about whether or not we have concerns, we do have concerns, but the alternative is that Ms. Gardner stays in custody until this disqualification issue is resolved. And I think, Judge, once you hear what we found out during the depositions this week, you're going to see that this is much, much bigger than any of us ever thought a week ago. And I can tell the court what happened.
Really?
Yes, Judge. I can tell the court what happened during the depositions this week if you would like to know.
Please tell us. Please tell us. He wouldn't make that representation unless something really happened.
And I'm concerned, and I've always been clear about that.
He's begging to tell the court, as you can tell.
To me,
And here's the problem. The judge doesn't really want to know, because if it's disqualifying of the state attorney, it may disqualify her if she hears it, right?
Wow. That's
So
interesting.
she doesn't want to hear it. She wanted to send it to another independent judge to determine. It's a really complicated issue.
Wow. And that, by the way, they deposed the Secret Service, I think, over
Yes, Judge.
over getting, phone call and digital forensic information. So they were deposing, I believe, the Secret Service. But let's continue to listen here.
That's not easy to do either. To depose a federal agent.
Let's say hypothetically I do disqualify the state attorney's office. I'm cognizant of that, but the state should be able to burn the midnight oil in my mind and get.
She doesn't want to lose this case. She wants to keep this case. It's a high-profile case for this judge.
Yeah, makes sense.
And we didn't know right now, and Mr. Hill is present, Mr. Tassoni as well. Your Honor, I don't know how clearly I stated this in our motion to disqualify. I don't know how clear.
Mr. Bias, not all people. You have to talk to the microphone.
I don't know how clearly I stated this in our wherefore clause, and I may amend. to make this very
Wherefore.
clear, but it will be our position that not only are we asking you to disqualify the entire Fourth Judicial Circuit, when the governor, I assume, does the governor's assignment for the new prosecution team, we're going to want all of the electronic data to be sent to a new filter team so that there is no way that this can happen again. So that the new state attorney that gets the case has it completely sent through a filter team, so they don't end up with our text messages, our emails, our attachments, our timelines, and every other thing that the state had access to and is in possession of. So that's going to be another delay that the state can't burn the midnight oil on, because that's going to happen in our minds for this case to be secure and non-prejudicial to the defendants.
All right. Do you want to tell me what your position is based on the discovery that you conducted?
Our position is we're ready to go. With the exception of time that we need to get the transcripts from the depositions, so I would say 10 days. The state did speak with us this morning. Their timeline was acceptable in terms of our issue. The bond issue is not our issue. That's Ms. Gardner's issue. Tangentially, though, it does affect, because what you're saying is, what if the state uses the document that I'm highly contesting, or the text messages that Ms. Gardner is highly contesting against Ms. Gardner in her bond hearing? That would pose a problem for me, because again, it would be one more person, you or anyone else, that would have access or actual knowledge of what's in that document. So I don't have a suggestion there, but I do have the same concern that you were sharing this morning.
And that would disqualify the judge.
Predict what they may or may not show.
Okay.
And Judge, we are going to supplement our motion as the court asked us to inform the court today. And we're going to move to actually dismiss the indictment, Judge, based on the fact that the state and its law enforcement officers, and this is sworn testimony, were reviewing both Ms. Gardner's iCloud return and her Google Drive return before it ever went through the taint team, that was knowing and intentional acts by the law enforcement team that was working with the state. And that when they had questions when reviewing those about whether or not something they were actually looking at was attorney-client privilege, they would call Ms. Stifler and ask her, describe it to her, and ask her if what they were looking at was in fact attorney-client privilege communications. And so it's our position that the spillage of her attorney-client information throughout the law enforcement teams, which are Category A witnesses expected to testify in this trial, will amount to sufficient prejudice that we can never put the genie back in the bottle and Ms. Gardner can never get a fair trial. I will let the court know that we have some research to do. We are not taking this lightly. We want to make sure that we are able to adequately support the assertion that I just made to the court before we file our supplement. But we do think that what we established during the depositions this week, in fact, one of the things we learned, Judge, is that my client's iMessages from her iCloud, which we all know did contain attorney-client communications, were circulated to all or most of the primary members of the law enforcement team by email before the taint agent, who was never trained and had no protocol and had never done this before he even looked at them. And that the spreadsheet with all these messages that were circulated was open and reviewed. And that the law enforcement members did in fact identify attorney-client communications in that spreadsheet, which was by another court's order, right, in February of 2023. All of that was supposed to go through the taint agent before anyone that was part of the prosecution team looked at it.
Okay.
So we got some real serious issues with the evidence and the wiretap and not the wiretap, looking and listening to attorney-client
Judge, I would
information.
ask for 2 weeks for
That's
us to
Jared's
file
widow in the black,
qualify.
looking ahead, Kirsten.
I don't know how long the state would need to respond to that. And then
So that's still putting you off the timeline that you're indicating.
I know, Judge, but I'm stuck between a rock and a hard place.
We'll get Tim to break this all down as soon as this ends.
Do you
Yeah.
have a moment to try to talk to your colleagues?
Yeah, well,
Lily's client.
yeah,
my client.
yeah, let me, one moment.
Here's the problem when you got multiple lawyers and when they're saying we want to make sure that everybody's available, the judge should be
So
saying, listen, you got 3 lawyers. One of you can be there. We can schedule this.
Court assessment earlier that
Mhm.
if we can resolve the disqualification motion in a timely manner, we can then set the bond motion.
Okay.
And that satisfies the concerns that Mr. Fernandez has.
Okay. And you talked to him about it? I mean.
We're in a different posture. I don't need to talk to
Yeah.
Mr. Fernandez.
Right,
He-
well, this is the thing. You all know, I have not seen one shred of anything, and before, this is the other thing I was gonna ask you, is it your thought, so you're gonna supplement, right? The state's gonna respond. Is it your thought that I do need to ask the chief judge to appoint another judge to review this material, or is there an agreement?
That's the best idea.
I spoke to the state and Mr. Carodi, and I'm just addressed for the record. I don't believe we need another court. The emails, the text messages, everyone and their brother had them in this case, far before Next Point even became an issue. And the documents that the state intends on using against my client, they've seen, they've read, they intend on using them. If the court, if you see that document, it makes no difference. That privilege has been eviscerated unwillingly by the defense. And I would say that if there was any concern for the court, I would waive any.
I was going to say
ability
she should
to
ask
accuse the
parties to
court
waive
based on this very limited
disqualifying
issue.
her.
Because, if the court has some concern, like, well, then I'll see it and then the defense will try to accuse me. Absolutely not. I think this court is the proper place to hash all of this out.
All right.
Sounds like they don't want the chief judge reviewing it.
Am I understanding? Before, there was an agreement that certain documents, certain communications, those things, my understanding was there was a great majority of the information that you all were talking about was agreed to by the state of Florida, that was attorney-client privilege. Is that still the case? Or are you still, my understanding was only kind of one document or thing on Mr. Fernandez's part. There was, but the state indicated it was evidence. This defense said it was attorney-client privilege. And it was my understanding, it was only one contested document. Is that still the case?
There's one contested document that the state is in possession of, admits that they've looked at and intends on using. That's what you're speaking of specifically.
Right, and so I'm asking, is that still the case, yes or no?
Yes, there are hundreds of what the state agreed to were privileged communications that were uploaded to Next Point that the agents had access to. Their position is, yes, they were privileged, but no, we have never looked at them. No one has ever looked at them, albeit everyone had access to them. Their position is no one's ever seen them, except for the one document. So,
Right, so I can clarify, sorry, I know, I don't mean to interrupt Mr.
You're
Geisler,
fine.
but I somewhat agree with what's being said. I do think that the depositions made clear, and that's been, the information brought out of depositions is the information contained in the state's filed written response. But we have been clear from the beginning, there was an agreement between parties to send cell phone devices, MacBooks, Apple Watch, and an iPad through a taint team. The Jacksonville Beach Police Department executed over 70 search warrants in this case, including to Google and to iPod. They received that information directly as the affiant and custodian of those records. Those records are at Jacksonville Beach Police Department, just like any other evidence for any case we stored with the presiding law enforcement agency. There is one document that we discovered while reviewing this evidence that I believe is evidence. I don't believe it, one, is a communication, or two, it's confidential, or in any way a privileged attorney-client communication. That document was brought to my attention by our analyst. I reviewed it. I determined that there was nothing about it that suggested it was from an attorney to an attorney, etc. I mentioned it to Mr. Geisler, and we are disputing that one document. The rest of what they're talking about is the state of Florida never had possession of any of these items. They were in the possession of a law enforcement agency. Once we realized that there were attorney-client privileges, documents, or text messages on this information, which we have purposefully taken folders, left them sealed and zipped, and didn't review them. The analysts were reviewing other evidence that was not attorney-client privilege. Those were then sent through the taint team. The state of Florida and law enforcement has never read any emails, any text messages, any client communications other than this one document. The state attorney's office agrees. I read this one document. I intend to use it. So I just want to be clear about all of that, because Mr. Curry is saying he wants to just dismiss the indictment, and needs to do research to adequately support his assertions. I just want to be clear, at this point, they're assertions. We have no, I haven't seen their supplemental motion yet. I think I have previously said that the communications, I took Mr. Dreiser and Mr. Carruthers, Mr. Dreiser's word that whatever emails and text messages were privileged, I took their word that they were privileged. We didn't look at them, we removed them, we deleted them, we sent them through tape teams. To the best of our ability, we tried with good faith never to purposefully or intentionally read anything. Any disclosures or any possessions were inadvertent, and we took whatever steps to remediate our possession of these when we realized that we have things we were not supposed to have.
Can I ask you a question? Do you believe, based on what Mr. Dreiser is saying, okay, that the court could just look at metadata and not the exhibit? Do you understand what I'm
I
asking?
understand what you're saying.
So
I don't think you-
file, give me a second.
Yes, ma'am.
So file A, okay, if I don't need to see the contents of file A, that's why I'm asking you all this question. I don't see the content of it. If you all agree that it is in fact attorney-client privilege, there will be no need for the court to examine that document then to determine if whoever had access to it. That's what I'm asking. Are y'all agreeing or are you not agreeing? Or is the agreement just as to one document, or are you all saying it's multiple documents? And if it's multiple documents and there's no agreement, I'm gonna disagree with you, Mr. Dreiser. In an abundance of caution, I ask the chief judge to have someone else review it, settle your disputes, and then I'll look at the metadata.
And Your Honor, my response to that would be, I have not seen anything or reviewed anything other than the document we're disputing is privileged. Two documents. Actually, one of them I reviewed, one of them I was told about the contents. I have not seen or reviewed any of the, I think he said 66.
It was also
emails.
sent to you in the same email,
Yes.
two
So
documents.
y'all will talk to each other. Is there an agreement or is it not?
It's a little bit more complicated. I know,
I'm not
we're not in agreement that the one document, that is going to have to be reviewed by the court. The
Okay.
other documents, which are emails, text messages, and phone calls, there are over 100 at least communications. There's no question that they're privileged, and there's no question that they were uploaded to NextPoint. The only and I wouldn't allow, it would be over serious objection by the defense that anyone ever get to look at those. So no court is ever going to get to look at those.
Give me a moment. Do you agree?
I do not. I believe that part of their argument, because my testimony and our response and what I believe will come out of the hearing, is nobody from law enforcement and the state attorney's office looked at any of those items that they're talking about, the text messages.
I agree with that.
So why aren't you agreeing that they're attorney-client privilege?
Because I don't know what they say, and I don't dispute that there are communications between them and their clients. My issue is the prejudice, which is the second prong of their motion. If these emails and text messages are about scheduling, and the court's going to disqualify and dismiss an indictment because we had theoretical access that we could potentially hypothetically open a scheduling text message, I think the court needs to weigh that of how prejudicial the mere access is. Putting aside the fact that we didn't read them, the fact that I have a closed sealed envelope on a table next to me, it matters to me what's in that envelope because they're saying it's a communication. I'm not disputing that. I take them at their word. But what it contains is relevant to the remedy that they are seeking because they have to prove that they've been materially prejudiced in some way. The state of Florida has somehow inured a benefit to trial by having access to this information, that I will have evidence I should not have had, that I will have trial strategy I would have otherwise not known. So I believe that an independent magistrate should review it. I will point out that when we had this agreement in front of Judge Carbula on their motion for protective orders to stop us from doing a forensic extraction of the phones, they were in favor of a magistrate reviewing everything. So at some point, we were all in agreement to detain me. They wanted a magistrate to review all the communications and remove attorney-client and marital privilege. The court said, no, the state can look at marital privilege. There was no court order. We agreed. We are not going to look at attorney-client privilege. We don't want to look at it. We have no intention of looking at it. Anything that has happened has been inadvertent and has not prejudiced them. So the contents of those messages are relevant to that prejudice, that finding of prejudice or non-prejudice.
With the exception of two documents
Yes, and I'm
titled confidential communications sent by Miss Butler to Miss Stifler before the taint agent ever got a chance to look at them. And our expert's going to come in
I'm fine
here.
with the court reviewing those two documents because I don't believe their communications are privileged.
Our expert's
They're
going to,
they're contesting them.
and our expert's going to come into this courtroom and say that on such and such a date, Mr. Fernandez emailed our office and our attorneys only those documents. The taint agent is going to come in and say, had I seen the email with the attachments, they would have been privileged and I would have filtered them out. That's what we heard this week in the testimony.
All right. It is very clear to me that.
Judge is going to
sooner
appoint the
rather
chief
than
judge.
later. And when I say sooner, Ms. Gardner share the same concern?
Judge, our
With the
concern.
same,
Our concern is slightly different in that, Ms. Stifler spoke about there was an agreement with the cell phones and somehow that agreement didn't apply to her iCloud that was seized after the agreement that everyone knows has the same text messages that are on her phone. And so I guess what I'm hearing the state say is that because law enforcement couldn't look at the phone, they went and got her iCloud.
I just want to be
okay.
clear about that. What I'm saying is, we had an agreement, we attempted to honor it. You're dealing with hundreds and hundreds and hundreds of megabytes of data. We did our best to send it through the filter team. We made extensive efforts to prevent disclosure of attorney-client privilege. The two documents he's referring to are just evidence. I had no idea they were emailed to Mr. Ricer by his client. I found them from an independent source. But I just want to be clear because they keep saying these things on the record that I dispute. And I just want to clarify the record. I think that we need an independent magistrate to review everything because I think that prejudice needs to be determined. And if Mr. Dreiser and I are agreeing whether the contents of this document are even a communication, then I'm not comfortable with your honor reviewing it.
I've said this from the outset. A court hearing a case of this magnitude, okay, I want to avoid any appearance. I appreciate the,
We don't
I
object.
appreciate the thought expressed by you, Mr. Dreiser, but my concern runs deeper than that, okay? So I've said it from the outset. I'm the one that offered it. I've talked to Chief Judge Day, and he's willing to expend the resources. However, I am going to request, it is very apparent to me that that is a necessity. And I am also cognizant of the time frame and the work that all parties have put into it, both the defense and the state attorney. That's why I need a clear understanding of where your agreements are, where your disagreements are, because I don't want to send this to another judge with you all still essentially disputing or arguing about what the magistrate is or the other judge is going to look at, okay? So I'm going to ask the chief judge to appoint another judge to review these materials. I don't want to have access to it. I don't want to review it for a number of reasons. And I think it's only judicious and fair that if it is contested, what these documents are, whether they're privileged or not, a judge then ultimately, let's say we go through hypothetically an entire trial, there would be no way to any imposition I would have. Like, I don't want to have access to something that apparently or may not rightfully be a part of this case. What I do need the parties to do is based on your discovery. So we have these initial motions. Ms. Gardner says she's going to amend. Mr. Dreiser, are you amending or no?
If I did, it would be of no real significance, just to make sure my remedy is clear and maybe add what we believe we learned in the depositions. It would not be of any significant,
Okay.
but I'll have it done whenever.
This is what I need you all to do. I need you to supplement both pleadings with what is in fact contested, okay? What is agreed to and not agreed to. The agreement should be, in my mind, the first part of the supplement. These now two documents that the state has admitted you are, and then, so that is the first part. The second part should be, what you all do not agree to, what you want the magistrate to look at, so you can, out of this terabytes and terabytes of information, to hone in. And this is all for efficiency, and also if you want a decision done quickly, that you all kind of narrow the issues for the judge. I'm going to ask the chief judge to make the appointment. He should be able to do it hopefully by the beginning of next week. I need you all to supplement. How long would you all need to identify those things?
Despite our talking on the record today, I think for the most part, we actually agree on a lot of information.
I agree with that.
So
Well, that's not the impression you've given me.
That's my morning report.
so
Actually,
I'm
Mr.
like-
Dreiser and I and Mr. Cody and I spoke this morning. I think a lot of these things, there's little dispute as to certain pieces of the evidence. Our dispute is to the law and the remedy. So we will get together and we will come to some understanding.
Well, Matt,
What I'm understanding from you is that you want the magistrate to, or the judge to look at certain portions that you have not seen in order to say if it's to separate that these documents or these files or these, whatever it is, this is related to scheduling, therefore.
Right, I don't know what they are, but I think it is germane to their remedy they're seeking as to whether it prejudices them or not. The fact that I merely have access to their scheduling, I mean, I'm using that as an example because obviously I don't know what's in there. But it makes a very big difference if they're discussing their trial strategy versus if they're discussing scheduling.
From your deposition, were you able to kind of like narrow that down, or is it just hundreds and hundreds of files or things? Or
I narrowed the scope of the depositions to the documents that are in dispute. The other emails.
how about we start with that?
The other email.
What do you all think about that?
Here's the
Start
problem.
with that.
Here's the real next big issue with another magistrate reviewing all the emails, which in a vacuum, I don't have a problem with it. That magistrate, what Mrs. Stifler was referring to in the initial hearing, was going to be a magistrate, a special prosecutor, or a filter team person. I would have had no problem because they're totally isolated. And I assure you that person would have never reached out to Ms. Stifler to find out whether something was or was not privileged. But in this case, if the magistrate's going to do that, and the magistrate may have, or the circuit court judge, whoever Judge Day appoints, and then has questions, the state attorney's office is going to have to bring in a special prosecutor to handle those hearings. It'll be like a federal castigar hearing where the AUSAs have a whole nother team to handle the hearing because during that hearing, they would be potentially accessed or being asked questions or being asked to argue
Go
that.
back to my original question.
Yes. You're
What about we start with the two documents that you all can test,
that's fine with me.
and then we table what Ms. Stifler is suggesting?
Sure.
Then you all don't have to supplement. You all can identify, we know what it is, right?
Absolutely. There's no confusion about those documents, who had them, when they had them, what they intend on using. That would be very simple for this. There still needs witnesses and a hearing to hear the timeline. But yes, we can absolutely start there and perhaps finish there.
That seems more prudent.
Yes, ma'am.
Do you agree?
I'm gonna agree.
There we go. It happened.
At the state attorney's in the courtroom.
Where's Ms. Gardner in all this? Do you agree or no?
Yeah, Judge, we're going to supplement. I think our basis is going to be a little different. And that is, we believe that what we would call the state's effort, and by state, we mean the law enforcement team that's working with the state attorney's office, right? One state organization. That our concern is the effort to do an end around the court's prior order regarding the taint team by looking at the iMessages from the iCloud and the Google returns. So I don't think there's a dispute that there were attorney-client communications on those returns.
Is this something that you discovered during the depositions?
Yes, we had no idea. We had no idea that anyone had looked at her iMessages before the taint team or taint agent, because it wasn't a team, it was one agent.
Now I'm going to ask you all this: to settle that issue, do you would you like another judge to hear that, or can you agree, or would you rather me deal with it through the metadata?
I think for that issue, based on what the deposition entailed with Ms. Butler, which this was outlined in the state's written motion, so to me, at least, it was not a surprise. She discovered an attorney-client communication while reviewing something and realized it hadn't been properly detained, and then we sent it. That one communication, I think an independent magistrate could review. I never reviewed it, I don't know what it contains, but she could tell that judge in camera what it was without the state attorney's office present, and I'm fine with that.
Do you agree?
Yes, Judge.
Let me ask this. Have both defense teams seen that? Do you want a separate hearing for each defendant, or do you want to have it concurrently?
When it comes to their messages, I don't know
So
what
you're
it
requesting
is.
separate hearings?
Yes, Judge.
Sounds like they're not a joint defense agreement. They're
By the way,
separating.
yeah.
They want, yeah.
Yeah, this is big breaking news that they're now naming 5 co-conspirators. The names have been redacted
Your
on the
Honor,
documents.
for
Tim will break that down after
judicial
this.
economy, a lot of the same witnesses, it may be the same hearing for evidence, and then just like a Castigar hearing, I would be asked to be removed for a portion of the hearing.
Obviously, I'm not going to conduct them, so I'm just trying to.
Okay.
You recognize
keep it
Castigar,
as
right, Joel, from
detailed
the
as I possibly
Wendy
Yeah.
can.
Adelson case?
Request that
Sure
I
do.
want the judge to do
Learn that
so
word
he
from
can
you.
engage and figure out who he would like to appoint. So what I'm asking, what would be required of the other judge, which is my understanding, which I'm going to repeat back, is that you all have a contested document on Mr. Fernandez's behalf, two contested documents. And then on Ms. Gardner's behalf, there is a communication that was not, that was communicated to law enforcement. And
2 documents and 1
communication.
message or text or something.
And I don't know exactly what the ATF analyst reviewed, because I obviously did not ask her that in an open deposition. So it would be a question for the ATF analyst exactly what she has reviewed.
All right.
And because I know that the iMessages were circulated amongst at least 4 law enforcement officers, I do not know yet if any of them reviewed them also before the detaining agent was able to go through. In full disclosure to the court, we may stumble upon someone that's reviewed more than the ATF analyst.
You didn't ask those questions during the depo?
So,
How, if it was communicated to anyone else, or whether she talked to anyone else?
well, the problem is what she said is that she got the iMessages in an Excel spreadsheet that was emailed to her, and that there were detectives and other federal agents on that email. Obviously, she can't speak to whether or not those other people that were on that email did in fact review the iMessages. We've not deposed those individuals. I don't believe I've gotten a copy of the email that was originally distributed to know who exactly was on that email.
I don't, I can get it, I can make those people available. I will say, I mean, they can check them out, I don't have to take my word for it, but Ms. Butler was our analyst, so she was always the first and only person to receive and begin analyzing evidence before everybody else did. So it's unlikely, but obviously I will provide those names and I'll get that email.
All right. How long, I'd like to do this sooner rather than later. Do you want to come back next week?
For the,
Or, so based on my understanding and the parties, Ms. Gardner is going to supplement, correct?
Yes, Judge.
All right. How long do you need for that?
Judge, I'd ask for 2 weeks.
Okay. In the meantime, I will ask the chief judge to appoint an independent judge from this case. When do you want to come back for your?
to set? all we need really is the 10 days for the transcript.
When did the depo occur?
Tuesday and Wednesday.
There really wouldn't be a need for me to see you all. The appointment can be made, and then the scheduling would be with the other judge. I can put this on for status.
Yes, ma'am. Yes, Judge.
So you need 2 weeks. You need time to get the transcript, which it looks like, by my count, the earliest the transcript would be ready would be February 29th. If I count 10 business days, if you ordered it.
We did, and Miss Butler chose to read. I don't know how that.
That delays it because the deponent has to go with the court reporter and make sure she got it right, so it delays a
Would you
transcript.
all be prepared to supplement without the transcript or no?
Judge, I believe we would based on my notes from the deposition.
Okay.
There's the state
What does
attorney
your scheduling look like?
sitting in the courtroom next to the
Early
victim's
March,
wife.
so I know when to bring you back for status. What I'm saying is you would appear in front of the appointed judge, okay, to review. I'm assuming that judge will need time in order to process and do an order. I can come back
March 4th.
March 4th, anytime that week, or the week of March 11th, you can let me know where you are with the other judge. If you want me to do that, or, I was just gonna set this for a status at this point.
March 4th for a control date to see where we are with the other judge would be fine with the defense teams, Your Honor.
Yes, Judge.
Okay?
Your Honor, can we do March 5th? The co-defendant is set to appear not on the court.
I'll reset this date.
Okay.
You want the 4th?
Yes, ma'am.
I just set that as a status, on the Tenon case, knowing that, these cases would dictate a court date for him, okay? So we, on both, Mr. Fernandez and Ms. Gardner, we will come back on March 4th, 9 a.m. status hearing.
I have one clarification. Mr. Carodi is requesting the names for the email with the spreadsheet because we're in this situation.
Hey, Joel, you got new member.
How do you want to receive that? I'm not gonna.
Sarah Adams, 7 months served. I love that.
So,
I would imagine like a PDF or a printout and scan of the email itself that just shows the attachment would
She's
not.
asking you, she doesn't want to get it and give it to
right.
you.
How do you
How
want
do you
to
want to get it?
Ms. Butler can just forward it to me.
Okay, I'll have her do that.
Judge, I don't know that the email itself would be privileged. It's the attachment that's privileged. That was just the point I was making.
How do you know it's in it? I thought you hadn't seen it.
I haven't, but the way it was described to me was it was just forwarding an Excel spreadsheet with the iMessages in the Excel spreadsheet.
If you'll have,
Yeah. That's fine.
the agent forward directly. Okay.
And then lastly, Your Honor, the motion for our mitigation specialist to go to the jail, we're working directly with the general counsel from the city and the chief of the jail to resolve this issue. And I believe that we're going to be able to self-resolve it.
You are, okay,
I think so.
all right.
So that's an investigator like Monica
No, Your
who
Honor.
does mitigation. They're not a lawyer. The jail probably doesn't
Obviously,
allow
when the chief
non-lawyers
judge makes his
in,
appointment, that will
so they got to
communicate
get permission.
parties. I will see you all back on March 4th, 9 a.m. for status of both cases. Thank you all very much.
Thank you, Your Honor. May we be excused? Thank you.
So you got a lot of big issues, serious
Yeah.
issues.
Yeah.
She is
Uh,
in street clothes.
Let's
Or
try
at
to
least-
break this all down, Timbo. So first off, what do you make of this adding 2 co-conspirators? Is that sort of strange at this juncture?
Well, here's what you can have a co-conspirator, right? But they're unindicted. And you're saying, well, why do you want to do that? Because if they're a co-conspirator, their statements, which would normally be hearsay, are now admissible as a co-conspirator statement. So they can, if this defendant said something to one of these others, that now can be introduced as evidence as a co-conspirator statement, and it was in furtherance of the conspiracy. Okay, so say the defendant called Billy, and Billy got a hold of him and told him when the car is going to be coming, and then he put the tire. The person that called the renter, that's a co-conspirator. That statement can be now admissible. Otherwise, it would have been hearsay. Um, that's why you would do it. They got less culpability, but they've got damaging evidence that could be very beneficial for getting statements in, right? So that's why you have unindicted co-conspirators. That's why they called Wendy a co-conspirator, but she wasn't indicted, right? This is so much here. This judge is really smart. And to take a minute off this seriousness of this issue, is it me or does everybody kind of enhance when they say Stifler? When they say her name, do they all enhance? All I hear is Stifler, and I think of the movie Stifler.
Yeah.
That poor woman has to be called Mrs. Stifler the rest of her
Is
life.
that American Pie? What movie is that? It's American Pie, maybe? I don't know. Someone let me know. I don't
It's
remember.
one of those.
Yeah.
Everybody knows the name Stifler, though.
Yeah, it is kind of it stands out. Let's put it that way. The irony is I don't think we even really heard Jose Baez except for at the very beginning where he said he'd be listening in on a conference call. They said something about an Arthur hearing March
Right.
25th. Is that for bond? Is that what you said?
An Arthur hearing is a bond hearing where they have to produce evidence, and the judge will have to make a determination because of the capital offense if the evidence is great and whether or not there are any conditions of bond. It's an Arthur hearing. Normally, the state will produce one witness or a couple of witnesses to get over that threshold. Usually, they'll put an officer on the stand or someone to testify. And then the court will make a determination if she's a risk of flight or a danger to the community, or if there's any circumstances that would allow her to be on bond and not a flea or a danger. I don't think she's going to get a bond. I do not. I think this judge can do the Arthur hearing without any kind of problem, as long as they don't try to introduce any of these emails, text messages, or the iCloud. She's probably going to do that.
Okay, so the biggest issue here is basically the way, and I'm a lay person, which is good, I think, for
Right.
everyone, because I don't understand this, all the nuances. But the biggest issue, obviously, is the defense coming out and saying, and it's Attorney Dreiser, I think, for Mara Fernandez Saldan, and someone said, I think he was a former JAG lawyer.
He's a smart guy. Smart guy.
Yeah, you
Yeah.
can tell he's got a good command in the courtroom. But the biggest issue here is basically the defense is saying that that the state got privileged information before the quote unquote taint team was done going through everything that was supposed to be client attorney privilege. And because of that, they now want the entire state's team dismissed from this case. And you were
Right.
saying that the judge is nervous to even hear this testimony because she herself wouldn't want to be dismissed from this case. So now she is saying we're going to have an independent judge review this. Do I understand that correctly, Tim?
That's exactly right. And what we have is technology has caught up to the rules of evidence and the Sixth Amendment, right? In this case, we have, and it's kind of unusual because you don't normally have suspects having lawyers already, right? She had a lawyer before she was charged. So she was apparently communicating with lawyers before she was charged. So apparently they took her phone and went down through her phone, hoping to get messages maybe between co-conspirators, and they got lawyers. Um, so here's the other issue we have. When you're going through evidence like this, either a wiretap or phones, text messages, and you get a subpoena or you grab the phone, you should have a taint team. What that means is the first person that goes through those messages should not be anybody on the team that's going to participate, that can look at it and tell if it's between a lawyer and a client. And then what they would do is they would not copy that, they would skip that and not forward it to anyone. But if they did, in this case, it appears they forwarded it through an email with multiple persons in the email, so they can't say who opened it. And there was attorney-client privilege in there. That's a problem. And you can't take away the taint, right? It's like you can't take away something once it's happened. The equivalent, you're pregnant or you're not pregnant, right? Once you're pregnant, you're pregnant. Probably not a good example, but once it's been out there, you can't put the genie back in the bottle. And the state is properly saying, wait, if it did happen, what is the remedy? What is the damages? And what is the prejudice? So Stifler was getting it right. Judge, not only do you got to prove it's privilege, but then you got to make a determination what the prejudice is and what the remedy is. She was arguing they were only talking about scheduling, not about trial strategy. Now, if it's trial strategy, there's a big problem. That will probably cause that whole office to be recused if they got information on trial strategy. And what then happens is once they recuse or they recuse themselves, then the governor will appoint a special prosecution team from another circuit. Happens all the time. Every state attorney's office has an individual prosecutor, usually a pretty experienced person that handles all kinds of cases. And they're like number 1 or 2 in the office, and they will do all the governor appointed special prosecutions. So I think what they're trying to do is they're trying to link that information was shared with the state, that information was shared before the indictment, that the indictment is tainted, that we're going to try to file a motion to dismiss the indictment based on attorney-client information was utilized in getting that indictment. That's a long way to go. And I hope I'm explaining it right, but it's a long way to go. And this judge is smart because she doesn't want to hear it, because then they're going to want to recuse her. And she doesn't want to lose the case. The best decision is to appoint a separate judge who's not handling the case. Let them do it. Let them do in chambers reviews. Do it separate from each co-defendant and make a decision. 1, whether it was attorney-client. 2, whether it is prejudicial. And 3, what the remedy is.
Yeah.
So those are all the things they're going to have to go through.
Yeah, the state spoke out and said, look, we never read any emails or texts except for this one thread, I guess. Is that enough? I mean, bottom line, Tim, looking into the future, will this entire state prosecution team be removed from this case, do you think? That seems like a big ask.
It's a big ask, and I've had it done. I told you the other day how I got it done. It's not normal to be done. And you know what? Most times, state attorneys, when they have a conflict, and I give you an easy example. Say a relative of a member of the state attorney's office gets arrested, right? A relative, brother or sister. That office will always conflict off and have the governor appoint a special prosecution. And that's wise, because it doesn't help anybody. Because if the person gets off, then it looks like you got special treatment, and that's the way they should do it. Here, the prosecutor is saying, no, judge, we don't believe what I looked at is attorney-client privilege, okay? And she was saying it has to be communications, right? So that's another issue. It may not, even if she did see it, it may not be enough. But you got really good lawyers here. You've got really bad law enforcement. You've got a breakdown in the taint. You got a breakdown in people emailing possible privileged communications to multiple law enforcement agencies. These agencies work for the state. And I can tell you that a judge will say, Mr. Jansen, you know, you're a state attorney. You are law enforcement. They are presumed to be you. Okay. So that taint to that law enforcement, they might have to get another indictment. I don't know. And this team they might recuse the state attorney's office. That's a possible scenario. But I know what they're not going to do. They're not going to get this judge recused because she's pretty smart and she's protecting herself from handling this case.
Yeah. Irish McGlass here. Tim, by the way, they're calling it the Tim Jansen School of Law, which is Jose Baez's wishes he taught there. Joel, is there a possibility that Shanna's defense team can actually get the indictment thrown out, the entire indictment, due to this taint issue technicality? That'd be wild. Is there any real chance of that?
Well, probably not, unless now here's another question. The prosecution, Stifler, is saying she wants to use that document in evidence, right? Now I'm just looking forward. She wants to use it in evidence. The question is, did she use it in the grand jury for the indictment? Right? If she used it in the grand jury for the indictment, and if they determine it was privileged, they probably will get that indictment thrown out.
That's interesting. Wow. This could be a crazy turn of events here. Frankie Figs, one of our amazing mods. And by the way, Frankie, I told COE she better reach out to you, and I hope she did. Isn't it fundamentally unfair, Tim? We've talked about this, to have one defendant in jail garb and the other dressed normally. We keep seeing that. What is the deal? Why do we keep seeing that? It seems very unfair, as Frankie just pointed out.
Well, the question then is, why isn't his lawyers having him dress in regular clothes? What are they doing? Are they not doing everything they should be doing to put their client in the best light, like the other party is? I don't think the court would say, no, you can't dress in regular clothes. It's not important to them for some reason. And it seems like they are, it's important to her, Shanna Gardner's team, to have her dressed in clothes. Optics are important, especially when you're going to pick a jury.
By the way, Henry Tennant on the right here, he is the admitted trigger man who cut a deal with the state, and he's going to testify against his former landlord on his right in this photo on your left. And yeah, here we go. Brianna, welcome to Brianna, by the way, friend of the show, always here. Henry Tennant is star witness. Yes, he is. True Lifestyles weighing in. She's up there in Jacksonville. I requested the grand jury testimony. They said it's sealed. They did a motion for KM's testimony, one of Shanna's friends. So there you go. There. By the way, quick reminder, we're coming right back to you in an hour and 52 minutes at noon Eastern time. Got Phil Waters, FIL, and Phil, PHIL, Ramos, both with I think they have like 80 years combined in homicide, and there are new sketches in the Rachel Morin case and new information in the Rachel Morin case. We're going to look at that heavily and do some of the biggest and wackiest true crime. Did I just say true crime stories of the week? So please tune in at noon, and after that, I'm going to collapse for the weekend. COE, I didn't see what you just put up there. You took it down too quickly, but we will. Yes, this is true. Phil and Phil coming up. Jacksonville Beach Police, we found out, Tim, executed over 70 search warrants at the onset of this case. Is that a lot? That seems like a lot. Is that a normal, typical number?
That's a lot. That's a heck of a lot.
Okay, so there we go.
That's a lot.
We found that out as well. And again, Tim explained why now we are hearing about 5 co-conspirators. KCL, who's been all over this, by the way, Action News, Jacksonville recent documents also reveal one of Bridegan's relatives told police that Gardner had talked about hiring a hitman to take him out. Look at that. Not sure what to make of that, because this is coming from Jared Bridegan, but this is being reported by Action News Jacksonville. I love that name. That reminds me of
so Joel
Burgundy, but go ahead. Yeah.
So if they list that relative as a co-conspirator,
mm-hmm.
then that statement to her would be admissible as a co-conspirator statement, even though that statement or that co-conspirator has not been indicted.
Interesting.
Otherwise, they'd only be able to get it by impeachment, right? Like they did with Wendy. Did you try to hide? No, and then they'll call this witness. But that's only if she testifies or if she takes a stand. Otherwise, you'd have to get a co-conspirator statement in.
Emily reminding us that Jared did tell his brother that he was concerned for his safety. It's crazy. What about this, Tim? Are we going to see, we're seeing this custody battle, but you think the family's going to also, the Bridegan family is going to file a wrongful death lawsuit against Shanna and Mario? They're not going to get much out of Mario, but Shanna Gardner's got trusts in her name. I don't know if those are touchable.
Yeah, that's the problem, is that you have a lawyer who's, most personal injury lawyers or civil lawyers, not only do they want to file a lawsuit, but they limit who they file lawsuits against. They want someone who's got assets or an insurance. If you don't have assets and you don't have insurance, you're going to get a paper judgment. So a lot of lawyers won't take cases where they don't think they can get any money, unfortunately.
The COE is in here staring at my microphone.
KCL, man, she's on top of everything.
KCL knows this case inside out. I believe that Bridegan relative was Adam Bridegan, Jared's brother. He is not a co-conspirator, so she's clarifying all this.
Okay.
Henry Tennant does in fact look rough. What's this COE? She's telling me I have an echo, Tim.
A little bit.
Yeah, it's weird. I don't know why. Probably because the COE, Ethel just stepped in here wondering what we're doing at this hour. So KCL also told us 200 more pages of documents were just released. And last but not least here, Tim, Melissa Nelson, the state attorney for that county, was in the courtroom sitting with Jared's widow. What does that tell you when the state attorney is in a courtroom?
It tells you this is a big case. That tells you that the state attorney wanted the judge to know that this is a big case. I'm here. I'm in support of my team. And I believe the judge worked in the state attorney's office, so the judge will know that the state attorney's in the courtroom, and she's supporting her people, which she should do on a big case like this.
I'm going to bring this up. I think this is something the COE put together because it is the 2-year anniversary of Jared Bridegan's murder. Let's see what this is. I can't unmute it though. COE, can you unmute that, please?
We don't have rights to the music, so I'm keeping it unmuted. This is from Justice for Jared's Instagram page.
There you go. Okay. Breaking. So that is Justice for Jared Bridegan. There is a GoFundMe. The family needs support. We don't have rights for the music, so she's keeping it muted, but you see shots of Jared going on a whatever you call those, a walker mover, people mover in the airport. You see him there on vacation. 2 years ago, he was taken from us. Horrific story once again. Tim, let me leave you with this. Why don't people just get divorced? Why is all this happening? Why do we see this domestic violence? Why do we see ex-wives killing ex-husbands? And why do we see ex-husbands killing ex-wives, Tim? Please stop the madness.
Well, you have a society that doesn't value life like it used to. I don't know if it's social media. I don't know if it's the games that are giving out the kids, TV shows. It just doesn't value life. And everybody wants a quick answer. They want everything done right now. They don't want to wait. They don't want to go through hardship. And they believe the best way is to actually hire people. And they think they can get away with it. But that video was just so sad. Sad for the wife, sad for the kids, sad for our community, sad for society. And these lawyers are, they're doing their job. Now, I don't want to say they're not doing their job because that's what they have to do. But law enforcement needs to step up their game. They need to do things right. And in high profile cases, sometimes when you're in a rush, in a hurry to get an arrest or you do make mistakes. And those mistakes, if you got a good lawyer, they can catch them. And Now let's hope that the indictment doesn't get dismissed. Let's hope that the trial will go on and justice will prevail. But it's going to take a while.
Amen to that. I do believe the next hearing is either March 4th or 5th. They were saying March 5th, and then the date March 4th came up. So I'll have to get with True Lifestyles and KCL. Huge thanks to True Lifestyles and KCL for having our back. What I love about this community is that we actually help each other. Shaming a Jay's helped me with video this week. I try to do what I can on my part, even though I'm pretty dopey. The COE is always trying to lend a hand, and we really are trying to help each other, which is a nice change from the traditional news media where I come from, where it is so cutthroat and everyone is just stabbing everyone in the back. So let us continue to stay that way. As Meave Moen, his sage words, a rising tide lifts all ships. So we're trying to do that. You can see from Gen X Granny's comment here, legal help for the Bridegan family. They do need help with their legal bills. If you're able to help in any way, you can go to GoFundMe, punch in the Bridegan family name, and I'm sure it will come up, or you can use that link right there. Tim, once again, stellar work. We are switching merch stores at some point soon. And when we do, we're going to have like an independent guy. I think we're going to have to get Jansen School of Law shirts made up with STS with a logo. That'd be hilarious. So we'll have to get on that. Yeah. And
I hope I hope that Stifler stays on the case, because just saying that name makes us laugh.
What a name. What a name. And yeah, we do have temporary tattoos. My kids have Carm tat sleeves, and the second channel. We're going to be streaming today, Michelle Triconis. We've been streaming that Gavel to Gavel. The never-ending trial that goes on and on and on is on Surviving the Survivor Trials channel. Best trials in true crime. Tim, you're the man. Thank you to our global audience for tuning in. And again, we will be back today at noon Eastern time with Detective Phil Waters, FIL, and Detective Phil, PHIL, Ramos. And we're going to be talking about Rachel Moore and other true crime stories of the week. Until then, love you, America. Love you, Jacksonville. Let's think about Jared Bridegan today, 2 years since he was taken from this earth very unfairly. Love you, America.